The parents of a 15-year-old student recently filed a lawsuit against the school district over what they claim to be a sexually explicit assignment. Now, prior to the lawsuit, the girl's parents expressed outrage over the assignment at a school board meeting, video of which caught the attention of social media. The student, who is enrolled at the Las Vegas Academy of the Arts Magnet School, was assigned to act out a monologue that was written by another student. Well, the monologue depicted a woman coming out as lesbian to her ex-boyfriend and contained sexually explicit language. Now, what is the basis of this lawsuit against the school district, and what rights do parents have, if any, when it comes to the curriculum taught to their children in public schools? Well, here to discuss it all, attorney Matt Hoffmann with Battleborn Injury Lawyers. And thank you so much for joining us, Matt. We want to start with parental rights over curriculum. How much power do parents even have?
It's interesting, we've seen a lot of this over the last couple of years with parents getting more involved at school board meetings, et cetera, and complaining about curriculum. But as far as, what rights do parents have to dictate curriculum, not a lot. Where they do have a right is if something being taught or an activity that's asked to be participated in violates a bona fide religious or moral belief, then you can ask for a reasonable accommodation. Some examples of that in school, I know I went to school with a Jehovah's Witness child, and they objected to stating the Pledge of Allegiance. And they're given a reasonable accommodation. They don't have to stand. They don't have to recite it. You could also see it in biology class. Sometimes you're asked to dissect a cat or other animals, and people will object to that. And the schools will give a reasonable accommodation if that's a strong moral belief, and you don't have to do that, that project. And then with sexual education, some parents, for religious purposes or otherwise, don't want their children to receive sexual education in the school, and they are allowed, to a certain extent, to get an accommodation so that their children don't have to learn those topics. So those are examples of accommodations you can get, but they all stem from the First Amendment, the free exercise of religion, and a reasonable accommodation for a true bona fide moral or religious belief.
Okay, so regarding this lawsuit, then, do the parents even have a legitimate legal argument here?
I question this lawsuit. I question whether it's more of a PR seeking lawsuit versus something with a strong legal foundation. I mean, the facts are the assignment itself is that in theater class at an arts school, the students who are 15 are being asked to write a monologue for another student to read and act out. And this 15-year-old was asked to act out and read this monologue written by another student. So it's not even being written by the school. It's being written by another student. So the only way I could see this being viable, at least, at a basic level, is if the student actually objected to it, asked the teacher, hey, I'm uncomfortable with this. I don't want to read this, and then was forced to read it. Then perhaps you'd have a First Amendment argument. But I didn't see a lot of that, from the facts of the case. And, if the school is not writing the materials, if the school is not forcing the person to participate, then really it seems more like this was an attention-seeking situation where, the parents went running to the school board meeting and made a big scene. It went viral on more right-wing media without a lot of facts. And, based on what I've seen, I think that's more of what we're seeing here. And, for parents, if any parents have objections to material, again, you can express that to the school district and ask for an accommodation, but you don't have a right to dictate the curriculum being taught to your children. You do have a choice. You can homeschool them, you can go to a private school, or you can get involved with the school board and make changes that way. But you're not going to get this curated, curriculum based upon objecting to everything that's being taught to your children.
Yeah, I also think, I'm just wondering if it also brings to question what is sexually explicit, because when you hear something like that, it sounds like, from at least what we've said about what this child said, it doesn't seem like it was sexually explicit. That seems like something nefarious, if you will.
Yeah, I agree with you. I mean, I've read what the person was supposed to be reading. Now, if they were 10 years old, I could see the objection. But this is a 15-year-old, a sophomore, and again, going to an art academy. It had a slang reference to, the male genitalia, but that's it. I didn't think that it was, particularly offensive. Again, I see this as more of an attention-seeking lawsuit than anything truly valid.
All right, Matt Hoffmann, thank you so much for breaking down the law with us.
All right, thank you.